Let's break down these arguments right now. I'm joined by two very special guests. First up in studio, criminal defense attorney Rachel Kugel is joining us, as well as forensic death investigator from Jacksonville State University. My good friend Joseph Scott Morgan is joining us via Skype. Now, Rachel, I want to start with you. You're seeing a little bit of the prosecution and defense's closing arguments. I guess the main theme for both is what makes sense. So, what makes sense?
Well, I think also, what they're trying to do is to support the testimony that was heard based on some of the physical and forensic evidence and say, look, you don't have to look at this evidence as proof necessarily in and of itself of anything, but it should bolster the different versions that you heard. In other words, what makes sense, what goes together when all these puzzle pieces fit together. And really what the prosecution's trying to do is say, look, when you put the puzzle pieces together, what you should get is a guilty verdict.
Yeah, and they both persuasive closing arguments. We're going to let our viewers know what that verdict is, but not quite yet. I want to bring on Joseph Scott Morgan because, Joseph, you had an opportunity to read the ME's report. We sent it to you a couple of days ago, and you saw the different wounds sustained by Muhammad Knight. What should the jury have been thinking about in terms of those wounds?
Well, I think that there was a bevy of these wounds, that it was more of a defensive posture, perhaps, that this individual is in. And, you know, the problem is that this story, from me at least, has been so convoluted and the water so muddied along the way that it kind of leaves us scratching our head as to what did happen. Back to what our colleague was saying just a moment ago, the fact that both sides are trying to bolster their narrative that they're putting forth, and it kind of when you go back in that jury room, I can only imagine the amount of sweat that was generated back there, particularly when you're talking about the physical evidence that was left behind, the broken glass, the DNA, and all these sorts of things. It is such a dynamic event.
Yeah, absolutely. Okay, so here's what we're going to do. Let's take a quick break. When we come back, we're going to reveal to you the verdict in the Armando Baptista trial. We'll be right back. You heard it. Not guilty. A lot different than his co-defendant, Demetrius Elder, who was found guilty of the lesser charge of culpable negligence. Let's break it down. Rachel, first let me ask you, were you surprised by the verdict? Because when you think about it, the prosecution made a really compelling closing argument.
They did, but I think the defense makes a good point, which is the fact that he can be proven to have been in his car when this happened, I think is really what this case turns on for him, and why the self-defense, works in this case, is because you have, the right to be safe and free in your car just as you would in your home, for example, and the fact that the evidence really looked like the alleged victim in this case was coming into his car, he just won the argument that the forensics supported his version rather than the prosecutor's version.
Yeah, I mean, it was a tough case to call one way or another. I think these self-defense cases usually are that way. Joseph, what do you think persuaded the jury in terms of the physical evidence? I mean, we could talk about the Solo cup, the beer bottle, the glass in the car. What do you think really drove their decision?
Yeah, couple of words. Blood will tell. I think is the most compelling thing here. That the interior of that car is literally painted with this blood, and it really brings home. I think that if you're sitting in the jury box and you're thinking to yourself, "My God, that could have been me in that set of circumstances." That's what makes this so markedly compelling when you see the trail that's left behind here.
I got to ask you, Rachel, though, from just a different perspective here. We played the video. We saw how emotional it was. When you're standing next to a client, you're waiting for the verdict, and then you hear not guilty. What is the feeling like?
It's unbelievable. I mean, when you're waiting, I have to say, even as the attorney, even though it's not your life that hangs in the balance, you've put so much into it. And especially a case like this, where your client, your defendant, is not a typical sort of criminal, if I can, with quotation marks. This is the kind of case that keeps us up at night, right? Because guilty or not guilty, this is not a black or white case. This is a gray area. And so this is the kind of thing that really keeps us up. I've been in that situation, and honestly, you're sort of shaking while you're waiting for that verdict to be read. And when you hear it, I mean, there's literally a sense of relief and overwhelm. You feel it on behalf of your client. You feel it on behalf of yourself because you've put into it so much of your own blood, sweat, and tears, quite frankly. And I'm sure this defense team really has. You can sort of see it in the way they act.
It's also frustrating, though, and sad for the prosecution and also the family of Muhammad Knight, because they wanted justice here. They know who was the reason for his death. I mean, it wasn't a question of did someone else do it. We know who did it. It was Demetrius Elder and Armando Baptista. The question is why. So that becomes very frustrating on their part. Joseph, I'm curious from your perspective and your line of analysis, was there something missing from the prosecution's case that would have been necessary maybe in other kinds of cases, these self-defense cases, in order to secure a guilty verdict?
Yeah, I think that that if they could have proven that the decedent was just pure as the driven snow, and that he was just in a fight to save his life, and they didn't accomplish that. And I think, you know, you asked me earlier what my opinion of this case was going to be, and I told you I thought that it was going to be guilty. But to my surprise, it wasn't. It's not guilty. And one of the things I was basing that upon was the initial in the first case where they came back with a guilty verdict.
Yeah, guilty on the lesser charge. We thought that could have been an option here, but they didn't go that way. Okay, Rachel, Joseph, stand by. Thank you for joining us on the Baptista case, but we're going to come back and talk about Go to John. We'll be right back. Welcome back to Law and Crime, everybody. So we are waiting for the live feed in our live trial of the day. That's the Nicholas Go to John trial. Remember, this man is facing a first-degree murder charge in connection with the brutal stabbing death of his girlfriend, well, his ex-girlfriend's mother, Dee Dee Blanchard. Now, we know that Nicholas Go to John is an autistic individual who's on the spectrum. The defense is really highlighting that point because they want to say that he could not form the requisite intent necessary for first-degree murder. They are claiming that he was pressured and manipulated and coerced by his former girlfriend, Gypsy Blanchard, to kill her mother because Gypsy really wanted revenge against her mother in the sense that she was imprisoned by her entire life under a strange syndrome called Munchausen syndrome by proxy, in which Dee Dee basically created fake symptoms for Gypsy, confining her to a wheelchair, controlling every aspect of her life. And when Gypsy realized that something was awry and wanted to be free of her mother and start a life with Nicholas, she wanted her dead. There's a lot to talk about there, considering the fact that Gypsy Blanchard actually took the stand yesterday. But we want to analyze this case because there's a lot of different medical issues associated with it. And joining us right now is a very special guest. Psychologist Dr. Wendy Dickinson is back with us. Doctor, great to have you back.
Good to be here.
Yesterday was an interesting day in court. We'll talk more about Gypsy Blanchard on the stand, but the defense claimed that Go to John had certain issues. They brought out a forensic psychologist, Dr. Kent Franks, who was an expert that was called and said that, you know, everything that he needs supervision and he needs structure and he could pose a danger to himself or others. He also said that the umbilical cord was wrapped around his neck when he was born, and that, you know, there's different factors you have to consider for this man. He's not, he shouldn't be judged as any other kind of defendant. Curious your perspective on that.
It's a really interesting take on it. Most of the time with people who are autistic, we don't see that they're overtly dangerous or make decisions that put other people in danger. Several years ago in 2013, the American Psychological Association reclassified autism from a categorical diagnosis where you either have it or you don't to a spectrum diagnosis where somebody can be affected by it and impacted by it a small amount, or the majority of their life can be dominated by this diagnosis. So it depends on where somebody is on the spectrum as to how much difficulty they have making decisions, how much difficulty they have communicating, or how hard navigating life, relationships, career is for them.
So is it possible that someone on the spectrum can be easily manipulated by another individual, maybe somebody that they really love, maybe somebody who is creating certain ideas in their head, fantasies of what's happening? Because we heard a little bit of that testimony with Gypsy Blanchard. Is that a possibility that they could be easily manipulated in this case into killing somebody?
It's possible. It again depends on where they are on the spectrum. people who have autism typically have difficulty with social communication. So they have difficulty recognizing typical patterns of communication. They may miss humor or sarcasm or not be able to understand metaphors. So they can kind of get bogged down in the communication process, and it could lead to them being manipulated. The interesting thing is that most of the time, people who have autism are very focused on rules and structure and tend to be pretty rigid. And so this idea of knowing right from wrong and following a rule is actually something that we would see as a strength for people that have autism.
Well, let's see a little more discussion about this. When Gypsy Blanchard took the stand, it's very impactful to see how her relationship with Nicholas unfolded. So let's play some of her testimony and we'll get your reaction. Okay, doctor, I'm curious your reaction to seeing this, because one of the questions we keep asking in this case is, who is the victim? Is it Dee Dee Blanchard? Is it Gypsy Blanchard? Is it Nicholas Godejohn? So when you're listening to that, what do you think?
Well, research shows that people who have autism do struggle with decision-making, even everyday decision-making, especially when it comes to decisions that have to be made quickly, or there's a lot of pressure, or they're outside of their typical routine, or require communication with other people to make the decision. And what the research shows is that they report being experiencing higher anxiety than their neurotypical peers, and being overwhelmed by the decision-making process. So one of the things that stands out is this decision fits several of those categories, especially being pressured and outside of his normal routine. I think without interviewing each of them, it would be hard for me to say who's really at fault here, or who's afflicted with some diagnosis that impacts what's going on. But it's clear that there was a lot of manipulation and a lot of that all three of them were impacted by this situation. I don't think there's any question that Gypsy experienced abuse. I think the real question is, how much did she realize that she had other options? She could have potentially gone to other adults or authorities for help.
Let's talk about this now from a different perspective, the legal argument here. I'm back here with criminal defense attorney Rachel Kugel. The idea that what the defense is saying, that because he is an autistic individual, he couldn't form the requisite intent necessary. Can you explain if that's a valid argument? Has that ever worked before?
So, I mean, it can be a valid argument, but I think there are problems with it here. So I think it can be a valid argument, but it has to be subjectively that he didn't. Not just that someone in his position couldn't, but that he didn't, right? And we've seen this issue with, you know, Brendan Dassey comes to mind in the Making a Murderer case, right? Because he had some clear developmental issues that impacted his, you know, ability to give statements with the police, whatever, but he was still ultimately convicted. I think the problem that they have with that argument here in this specific case is that the defendant's own actions kind of belie the point, right? Is that, okay, he's got this illness, he's got this issue developmentally with his ability to conform his behavior to society's standards. That's not necessarily, though, the same as sort of an insanity defense or even a diminished capacity defense. They have to prove he couldn't make the requisite mental intent, and I think that's a problem here because of the way he acted, right? I mean, they engaged in planning. They planned a cover-up as far as getting rid of the murder weapon. There was a lot of planning involved in this that went on for, you know, days and weeks leading up to this event. I think that's a problem. Because it certainly shows that he knew what he was doing, that he knew right from wrong, that he tried to cover it up, and really legally that's the kind of standard they're looking at. So I also think that some of his behavior, quite frankly, is a little bit frightening, which isn't great for the defense, because I think that a jury sitting in their position is going to look at this and go, you know, this guy scares me, I am concerned about sort of putting him back out there. I think that's a real emotional concern as well.
Doctor, the idea that he had said, look, there was a good side and a bad side, I chose the bad side, does that, even if he recognized that, is it still possible he didn't really appreciate what the reality of what he was doing? And is that something that can be explored further on, that's something the jury has to take into consideration? Yes, you can say all day long, the prosecution, that he knew what he was doing, he deliberated on it, he made a conscious choice, but did he really know what the ramifications of this were?
I think it's definitely worth exploring. I think part of the answer will be, where does he fall on the spectrum? And to answer that, I would look at how he makes decisions in the rest of his world. Does he have a career that he's able to engage in? Is he able to make everyday decisions, including hygiene decisions, and be able to take care of himself? What kinds of social relationships does he have outside of this one situation? So you would be looking at a more global perspective of how equipped is he to know the difference between right and wrong and make these kind of decisions. One thing that I would add is that much of the time, people who have autism are average or above average on the intelligence scale. So while it definitely presents some challenges in everyday life, it's not a completely bad diagnosis. It actually, they have some skills and abilities that the rest of us don't. So the idea of being categorized as a terrible thing is not really how we look at it within the field.
Clearly there's misunderstandings and misconceptions about autism. I'm glad we can clarify some of this. I wanted to see if I can get one quick question from Joseph Scott Morgan in, though. Joseph, when you look at the actual slaying, the actual stabbing, the wounds inflicted, does that tell you something about the story?
Well, it's rather the killing itself is rather, it is organized in the sense that they plan this, but it's very frenzied. You know, when he got into the bedroom. But we see this from in all types of stabbing and all types of insults like this. This in particular is a very personal crime because it's not like he's doing this at some great distance. Just for a second, I got to tell you, one of the most compelling things in this case for me is seeing that CCTV images, those images the other day of him checking in at the hotel and thinking that this guy's just made a 580-mile trek from Milwaukee on a bus with a group of other people that he does not know in a completely uncontrolled environment, checks into a hotel and begins to plan with Gypsy. Relative to what they're going to do. Wow, I mean, that just that puts it in a whole new light for me personally.
There's a lot to talk about here. Now, I know our time with Dr. Wendy Dickinson has come to a conclusion. I'm sorry, Doctor. We want to have you back on for a longer time to talk about this. So anytime you want to come back on, we have a lot more to discuss in this case, including Munchausen syndrome by proxy. But have a great day and make sure to come back on.
Great. Thanks for having me.
Thank you. All right, everybody, let's take a quick break. We'll be right back.